Shavargo McPhee and the Queen.
Mr. Fitzgerald.
My Lords, I appear with my learned friend Gina Morley of the Bahamian Bar, my learned friend Amanda Clift Matthews for the appellant in this matter. My learned friend Mr. Navjot Atwal appears for the respondent. There is, as the court will know, the case, first of all, the supplementary case, which amounts to effectively a reply to the points put by my learned friend. There is, in addition, a supplementary case number 2, which raises the new point. My lady, I would respectfully invite the board if I could just outline the case on the main point and then reach that, but I'm in the board's hands if you wish me to seek leave first of all.
Well, our preliminary impressions were that you should be permitted to argue both of the new points that you have raised, without prejudice, obviously, to what we might think of them.
Yes.
Our preliminary view was that you should not be permitted to adduce the fresh evidence.
Yes, well, my lady, I wasn't going to pursue that. I had indicated to my learned friend. So that's good.
So we're doing well so far, then, aren't we?
Yes. No. So if I could just outline, and if I could perhaps take you to the case at 1.3, because that is a short summary of the highlighted facts, and make the necessary qualifications as appropriate. But if I take you, it's at page 1052 to our main case. We make the point there that the appellant made a confession at 4 p.m. on the 29th. That was a Saturday. Before he made that confession on the afternoon of the 29th, he'd been detained in police custody for some 31 hours, starting at 9:20 a.m. on the 28th of November. That was the Friday. During that period, he was taken out of his cell for long periods. We invite the board to infer, almost certainly for questioning, and certainly he alleged in his statement from the dock that he had been questioned both on the, he described it as the evening of the 28th and the morning of the 29th. Those would have been unrecorded interviews. During those earlier periods of questioning, which we invite the board to infer, he didn't have the support or advice either of a lawyer or a parent, or even an independent adult, and there was certainly no record of the fact that those the periods of questioning took place, or of any questions that were asked. Moving on to more common ground, we submit that from 7:50 p.m. on the 28th of November, he was given no food or drink for nearly 21 hours before he made his confession statement at 4:30 p.m. on the 29th. The judge himself found that he may, which is of course enough for the purposes, well have been deprived of food for long periods. He didn't actually do the maths of how long the period would be, but the period would have to be from the last recorded meal at 7:50 p.m. Until 6:30 p.m. the next day. And by the time he made his interview, that would mean he had had nothing to eat or drink for nearly 21 hours. And he obviously made that confession without the advice or presence of a lawyer and without the advice or support of either a parent or a guardian. It's true that Bishop Henfield was there, and clearly he was there in a pastoral and humanitarian role, but he was not someone who saw him privately or advised him or saw his role as protecting his rights. So he didn't perform the function of an appropriate adult, and we would respectfully submit he didn't qualify as an appropriate adult, as is generally understood. So if we turn to the brief summary at 1.4, can I just indicate the way we put the case? Under Article 19.2 at Roman 1, there is the right to be, if you're under 18, to be afforded a reasonable opportunity for communication with the parent or guardian. And our submissions are that means a reasonable opportunity for you to directly communicate with your parent or guardian, which means he should have been afforded an opportunity to phone his mother himself. Now, the police said, well, we made efforts to phone his mother and were unsuccessful in those efforts. But they didn't go or cause anybody in Nassau to go to the mother's address, which was the same address as his own address, and they didn't really take any efforts other than making those phone calls, or even on their account. And we say, given the importance of this constitutional right and the primary importance recognised both in domestic and international law of affording an under 18-year-old, a minor, the right to communicate with their parent, we say that of itself is a breach of the Constitution and that the judge should have so found. So that's really the Article 19.2 point. Then really the next 3 points are all stem from our complaint that there was at least very likely to have been questioning that was unrecorded during the period before the confession was made, and the fact that at his age he was deprived of food and drink and was not able to communicate either with a lawyer or his mother. And we say at Roman 2, the burden is on the prosecution once the issue of oppression is raised to prove beyond reasonable doubt that the confession was not obtained by oppression, that given the age of the appellant, and can I just amend it slightly, the combination of prolonged detention and the likelihood of questioning, the denial of food and drink to him for some 21 hours, and the failure to ensure any communication with either a lawyer or his mother, that did constitute oppression, and one certainly could not rule out that oppression was causative in him making the confession. And then section 22B provides for the exclusion if it's not proved beyond reasonable doubt that it's not rendered unreliable by reason of anything said or done or omitted to be said or done in the circumstances existing at the time. We say, again, the police had subjected him to prolonged detention, almost certainly to questioning that was unrecorded, failed to enable him to communicate with his mother, and failed properly to advise him of his right to...
Was there an obligation to record any questioning or not?
Yes, there is, my Lord, both under the judge's rules, Rule 2 and Rule 3 of the judge's rules provide that if there is any questioning, it should be recorded. Rule 3C.
What's the form of record that is required in the Bahamas, Mr. Fitzgerald? Is it a contemporaneous record? Is it a note afterwards? Is it a note of the fact that the interview's taken place, or what? Because it's varied, of course, in other jurisdictions from time to time.
Yes, well, my Lord, it's been held in the Roller case that the judge's rules apply, and the judge's rules, therefore, if we look at Rule 3C, in the authority bundle, yes, it's tab 6 in the authorities bundle, volume 1. So, really...
These are the old English judges' rules.
Yes, then they've been held...
As from, well, quite old, yes. Right.
Yes, and...
Well, pre-Pace.
Yes, long before.
Yeah.
Yeah.
But it's been held that they apply in the Bahamas.
Yes, in the case of Roller.
So,
I'm
is it
just
3C?
looking. Yes, 3C. When such a person is being questioned or elects to make a statement, a record should be kept of the time and place at which any questioning and of the person's present.
Yeah.
And then all written statements should be taken in the following manner, and then it deals with those. And I'm just...
It's just that, isn't it? That's as it used to be a long, long time ago for some of us. But
yes, I'm just looking at Rule 2, when after being...
No, that's after charge.
Yes, I'm so sorry. My Lord, the only other point is the four standing rules. Yes, it's at 1236.
But, I mean, looking at the rules, which one was breached here?
Well, if he was being questioned in the evening, as he alleged, in the evening of the 28th, that's to say the Friday, and in the morning of the 29th, that's to say the Saturday, then there was no record of the fact that he was being...
Well, wait a minute. If the custody record, which in this case is pretty inadequate, but if the custody record shows him being taken out of his cell for questioning or...
Well, for inquiry.
For inquiries, will do fine, yes. Yeah. And then put back. Would that comply with 3C? It probably would, wouldn't it?
Well, no, my lord, in our respect, well...
It would, you see.
Well, the prosecution's point, my lord, is that he wasn't being questioned at all during those periods. They're saying that he was taken out for inquiries, but their claim is he was taken out for inquiries, and then all the police officers said, well, I didn't question him. So he appears to have been, on the prosecution account, sitting around. But no, my lord, and they're saying, well, he was having blood tests and baggage checks during those. So we say, if you're saying that well, they're saying he wasn't questioned at all, but that's the point, that there's no record.
Yeah.
And so that enables them to say he was taken out of his cell at 2:30 on Friday. Yeah. There's a record of him being returned at 1:30 p.m. the following morning.
Yeah, well,
he was having a blood test.
Yes. Well, I've got the point that the record is bad. Yeah. What I was on was simply the question of whether 3C would be complied
yes, I see.
If the record was confined to taken out for questioning at such and such a time, returned at such and such a time later. And the answer, I think, is that it would. I know you say that's not what happened in the present case.
Yes. my lord, you're quite right about the judge's rules, and I'm obliged. Okay. But if I can take you to the police standing...
There can't be a record of the person's present.
Yes. I'm obliged. Could I just take you also to the full standing orders, which do tell you what should happen in Bahamas, and that's page 1236. So this is the full standing orders. 59 at page 1236. Station officer must give his approval if a police officer wishes to interview or conduct inquiries. The circumstances in which it is interviewed are in accordance with these standing orders. Where possible, a record of interview will be recorded contemporaneously on the special forms provided. Alternatively, a record which accurately summarises the interview must be made in the officer's pocket book as soon as practicable thereafter. The pocket. So, where a is complete, so it does. There is a more elaborate code set out there. Yes. Much. So, my lord, we would say that is that's what ought to have happened. Perhaps you have the point that I also take that it should have been done it should have been excluded under section 178.1, which is at Roman 4. But if I can perhaps it would help if I just summarise very shortly, going to page 1058, the key points that we highlight. And I will try and make this very, very swift. So we accept at 2.4 on page 1058 that he signed a detention record agreeing that he'd been advised of his right to legal advice. And you can see that in the bundle at page 10 of page 10. That he's advised. Now then, so he signs, at top left, I have been informed of the reasons for my arrest and afforded a reasonable opportunity to communicate with my parent. Yes. Well, he clearly hasn't been afforded any opportunity, so it's really a nonsense, his signature there.
No, it's a right to be afforded.
Oh, yeah, yes.
He's not saying I was afforded.
Yes. Well, he doesn't seem to have been informed of that right, because they just simply say, give us your telephone number.
Well,
her telephone number.
No, I mean, you may have better complaints, Mr. Fitzgerald.
All right.
This is simply an acknowledgement that he's been told that he can.
Yes. Yes, okay, I'll move on. Then he says at 2.5 that he was then asked for and gave his mother's telephone number, and that's in the voir dire at 1203. lines 18 to 25. Then the appellant gave two numbers, a mobile number and a landline. And then DS Lorenzo Johnson said at the voir dire that he had made efforts to contact the mother, although he said he did it at the voir dire on both days, but at the trial he conceded that it was only on the 29th at 2 p.m. Can I just give you that reference? That's volume 3, page 684. So Lorenzo Johnson claims to have made an attempt to call at 2 p.m. on the 29th, the mother. Sergeant Paul Johnson, who's the second Johnson, he said that he tried to make contact several times, both on the 28th and 29th, and we've given the board that reference, 286 to 287. And I think that's probably all we need of that. So one officer says at trial, correcting what he said in the voir dire, I tried to contact her at 2 p.m. on the Saturday, the 29th. One officer says I tried to contact her on a number of occasions, both on the 28th and 29th. And our point at the very bottom is that there is no entry on the detention record that any attempts to call the appellant's mother were made, although DS Lorenzo Johnson made a written record in his report dated the 1st of December 2008 of an attempt made by him at 2 p.m. on the 29th of November. So we make the point, the mother was never contacted during the next 31 hours, and that certainly the appellant never spoke to her, and no other means, that's to say going round to the address, which was the same address as his address, which he'd given them, was made. And we do take the straightforward point that he should have been given an opportunity to call himself, and that in the absence of that, Article 19.2 was not complied with.
Well, what is the article? The article says he's entitled to a reasonable opportunity to communicate. It doesn't say if possible. I mean, what is the position if they simply can't trace her?
Well, I suppose
you accept there must be an implied qualifications that if it's not possible to get her, then he can't have an opportunity.
Yes, my lord. Yes, there must be some implied limitation, but if you don't give him an opportunity to phone at all, so.
Why would giving him the phone to make the dialing improve the situation if it is true that the policeman made lots of attempts to dial it himself?
Well, can I just put two things? Supposing they give him the false phone, obviously, at least it's verified. It doesn't depend on them saying, well, I did phone the number.
Well, that's evidential.
Yeah, that's evidential. Yeah, I mean, in other words, he has been afforded the opportunity. He personally has been afforded a reasonable opportunity to communicate. Well, he's given the phone, and he said, "You have exercised your right to make an opportunity to communicate. Phone her." The other point, can I just make the other point? That I think there is evidence that he had a mobile. Also, if you give him your mobile and tell her to phone your mother, she sees it's you phoning her, therefore she knows that her son has tried to phone her.
Well, yes, I follow that's true, but are you really suggesting that policemen ought to let suspects in detention use their own mobile telephones?
Well, he was allowed to when he went to Nassau. 2 days later, yes.
That's not what I asked.
Sorry?
That's not what I asked.
Well, if they...
Why not?
Well, they could verify the fact that it's his... they could say, what's your mother's number?
All right.
We'll dial it.
All right.
It is because of the special rights of an under 18-year-old that we say, but that's the simple point we make, right or wrong, is that to be afforded a reasonable opportunity to communicate means that you are given the best opportunity that you personally can have to communicate, and that's by giving you either a phone and there was evidence that happened. I mean, apparently down below you could phone your lawyer, so all these people could phone their lawyer, and my Lord, in respectful answer to your point, they could say, well, I'm phoning my lawyer, they could phone anybody who wanted. But they, in other words, there was a phone available for the use, but that didn't phone to Nassau because it was outside the island. So that was the problem. So then he would have had to go either use the mobile if it extended to Nassau, or be given another phone which phoned outside. But at least he would then have made the phone call. And it would be verifiable because, well, my lady, my lords, one can be entitled to some scepticism as to whether this did in fact happen or whether they got the number right or etc.
So are you asking us to depart from the conclusions that the judge came to, that he could rely on the evidence that they had tried? And if so,
No, my lord,
so on what basis can we do that now?
No, I'm saying that the right that he had was to make a call himself.
Right.
He was deprived of that right. That's how we invite you to interpret Article 19.2. If we're right in that interpretation, he was deprived of that right. If he had been accorded that right, there would be no need for evidential findings because he would have just said, well, I phoned.
Got it.
So it's the byproduct of that. So we say, well, my lady, my lords, it is a short point, but it's an important one, and we say he must be afforded himself personally the opportunity to communicate with his parents, and the only means is either that you're given the phone and given the opportunity to phone, or that the parents are brought there, or told your son's in custody facing a murder inquiry. We will assist you in travelling to the island. I mean, these are not big distances, but between the islands. We've got a map if you want, but it's a different island, Abarco and the island on which his home was.
The constitutional right, which we're talking about here, is something different, isn't it, from the kind of requirements of fair interviewing and questioning.
Oh, absolutely.
It's there for, one assumes, a number of purposes, and it's quite separate from the appropriate adult type requirement in the questioning, isn't it?
Yes, my lady, it appears, I mean, I think it reflects international law requirements in the Inter-American Convention, the UN Convention on the Rights of the Child, about the right to communicate. But in any event, it's far stronger than anything to do with the appropriate adult.
But what's it for? Why is it there?
Well,
It could obviously be to provide support and guidance to the young person in custody, but it could also be because of the parents' rights
yes,
to be informed
yes.
of what's happening, something really rather serious that's happened to their child.
Yes. Well, we would say both. It's both the support from the child's point of view and the notification to the parent. In this case, your child is being detained on a murder charge. Of course, that means that the parent can then say, well, he really needs a lawyer. I'm going to get a lawyer to go out there, or get a local lawyer to go there. But in the absence of the communication, the risk is that they don't get any support. And with respect to the bishop, we say that he saw his role as essentially humanitarian and pastoral rather than as a protector of the rights of the detainee. I mean, it's perfectly understandable that he took that view, but it wasn't performing the role that has been held to be necessary for an appropriate adult, which is to advise in private and to safeguard the rights. If necessary, I mean, what we would say, the classic thing would be to say, well, you really ought to have a lawyer. And given the debate that arises in relation to our second point, the importance of having a lawyer when you make an equivocal statement, which may be maybe raising a defence of accident, maybe raising a defence of lack of intent. That's what a lawyer would say. Well, what do you mean by that? The gun went off. Let's spell it out. Or, of course, he might say, don't say anything, but he might well say, it's important that you spell out that this was either an accident or you didn't intend to kill or it was in the course of a struggle, instead of which we have this rather half-baked point about there was a struggle and the gun went off. And so that essentially that's our point. Could I just continue with the chronology very briefly? The first period out of the cells, we accept my learned friend's point that he didn't expressly allege that in that morning, or that Friday morning, after he was taken out of the cells for inquiries, he didn't say that he was interrogated. But he was taken out for inquiries, and we say it's a reasonable inference that he was questioned. And certainly there's no elucidation as to what inquiries mean there, although one of the officers said inquiries includes interrogation. So that's at 2.7. If I can move on to 2.8.
Well, what other possibilities are there?
Well, I suppose
apart from the blood test.
The blood test or baggage check. No, but my lord, we say the reasonable inference is that they're not going to sit around not questioning someone who they just arrested on suspicion of murder for 24 hours. And when they took him out of cell for inquiries, they did question him.
Did the judge make any finding about what was meant by inquiry?
He didn't make any finding one way or the other on this because he simply said he didn't believe anything that
Yeah. But I mean, from your point, it was rather important to know what that means. Or...
Absolutely, my lord. And I accept that there's a non-finding, or there's an absence of a finding in this respect. But we do invite the board to find as a matter of really inevitable inference that he wasn't taken out of his cells for those 3 long periods for a blood test which took 15 minutes and probably took place in the middle of the night, about 12:15, and the baggage check, which we know took half an hour on the 28th.
You say that the only reasonable inference
Yes.
is that inquiries must include interrogation.
Yes, and my lord, can I just make one...
And since the other provision we looked at earlier,
Yes.
Even though it's much looser than one might perhaps have hoped these days, nevertheless, it doesn't indicate, if there were interrogations, it doesn't indicate when
Yes.
or who was present,
Yes.
as my Lord Wilson pointed out. That was one of its requirements.
Yes, I'm grateful, yes. My lord, the other point I make, the prosecution rely on the fact that Corporal Smith, who was the local Abacar-based officer, says that on the 28th, it was only on the 28th, he said, that there was a threat because there were lots of people milling around outside. So that's on the Friday. He said it had died down by the 29th, and that's at page 203. And he says it had died down. But just imagine this situation. If you really think there's a lynch mob out there milling around in the streets, you're not going to take someone out of his cells unless you've absolutely got to for a good reason. You're not going to just take him out and have him sitting around.
Do we know whether these are individual cells?
I don't know, my lord. No, I think yes.
They may be, they may not.
Well, would they be individuals? I understand it would be one big cell, my lord.
Well, that's the point.
Yes.
I mean, you're entitled to speculate. Well, I don't know how well you're... It may be unwise to speculate about what they might have done when nobody's ever been asked the question.
Yeah, no, I appreciate it.
And especially if he's in a cell with other people.
Yeah. Well, he's back in the cell for sleeping. I mean, it's not as if they're trying to isolate him.
We just don't know. No one has ever asked these questions.
No, I know, my lord. I appreciate.
I understand.
My lord, I do appreciate that the board is faced with some difficulties, but perhaps we can just firm up on that.
What you do say is that it beggars belief that he, on both the Friday and the Saturday, had been out of his cell for some considerable time, not being questioned, and that the only questions are the ones that are recorded on the bit of paper at...
Yes, at page 32, is it?
23.
30, yes, 31 to 33, yes.
23?
Verse 23.
Yes, the first questions are at 23, yes.
Yeah.
Yes, my lord, yes. So the ones that are typed out, yes. And then there's the confession, yes.
Yep.
Yes, my lord. Well, also, we know that the bishop is phoned and told, come and take a statement, not come and we're going to interview the guy for the first time. They know that they've got a confession coming. And how do they know that? The answer is because they've been asking him some questions beforehand.
Yep.
That we say again, that's an inescapable inference. Well, the board has the point, my lady, that I make in about the second period out of the cells at 2.8. Then he's recorded as being given lunch at 3:50 p.m. and a further meal at 7:50 p.m. And we can see that at page... the meal is at 7:50 p.m. at page 12 on the 28th. After that, there's no record of him being given anything to eat or drink between then and when he gets the Kentucky Fried Chicken 24 hours later at the top of page 15. He does complain to the bishop that he's hungry. The bishop does ask the police, has he been fed? They don't answer. And the bishop then says, well, get him some Kentucky Fried. Even then, he doesn't get that until after he's made the confession. So we do make the point that, and the judge himself made an express finding that he may well not have been given anything to eat for a long period. But we make the complaint, the judge should have confronted the fact how long that long period was. Corporal Smith says that if we go over to the next day, the 29th, that things had died down by then. We know at 2.8 at page 1060 that the appellant was again removed from his cell and taken at 2:18 p.m. for further inquiries, and then the suspect arrived downstairs nearly 11 hours later at 1:30 a.m.
What does CDU mean?
Central Detective Unit? Central Detective Unit, yes. Central Detective Unit. Central Detective Unit. And so we again say it seems inevitable he was questioned. He expressly alleged, this is in his statement in the voir dire, pages 310 to 311, that he was questioned that evening and threatened but not beaten up. Obviously, if he was questioned, as we invite the board to find, no lawyer or parent or appropriate adult was present, and there's no interview record or any other evidence as to what transpired while he was there. At the voir dire, he says, then later on that evening, they took me out upstairs to the CDU department where they asked me questions. And he does allege repeated questioning. Then it's true that there is a reference to a blood test being taken, and although it was recorded as 12:30 p.m., the doctor suggested that it might have been in the night, so it may have been a misprint for 12:30 a.m., and that's the doctor's evidence is at volume 2, page 559. Then if we turn to the events of the 29th at 2.10...
So where do you say he had his food?
The last...
You see, you say that he was recorded as having been given lunch
Yes.
at 10 to 4
Yes.
on the Friday afternoon, and a
Yes.
further meal at 10 to 8.
Yes.
that day,
Yes, it doesn't say.
during the time when you say he was upstairs in the CDU.
Yes.
So you think he was fed there rather than in the cell?
Well, my lady, yes, I don't see any reason why he shouldn't have been. I mean, it doesn't specify where he was given something to eat. We would say there's no reason why he shouldn't be given something to eat in the interview room.
What about the note about checks?
Well, again, my lord, they don't say he was checked in the cell, and
I see.
yeah, so there's nothing to say where he was checked.
Mm-hmm.
And the role of Corporal Smith, he's the local, as it were.
Yeah.
So he's monitoring whether the person is okay. There are some interviewing officers who've come from off island, if I can put it that, to interview him. So it wouldn't be inconsistent that he's checking him from time to time to see if he's okay, even if he's out of the cell, because he's the local police officer with the duty to monitor well-being, and there are obviously quite a lot of officers who've come for questioning and other things from off island. In Lorenzo Johnson. Lorenzo Johnson was from Nassau, wasn't he?
I may have been from Freeport.
Oh yeah, I think Lorenzo Johnson was from. Anyway, he was not a Barco-based police officer. I think he came from Freeport. That's right. So then, if I can take the board to the events of the 29th, we know that he was checked during the night at regular intervals. It was recorded that he appeared to be in good health. There's no record that he was given either food or drink during the night of the 28th or in the morning. And he clearly stated that he was given neither food nor drink until after his confession interview. And his confession interview, we know, took place at 4:30 p.m. None of the police officers either stated that they personally gave the appellant refreshment or that they witnessed the appellant eating or drinking. We've given you the reference. Can I just indicate, at 216, that's Lorenzo Johnson. At 284, that's Officer Ferguson. At 287, that's Paul Johnson. At 293 and 294, that's Paul Johnson. And what they weren't able to say more than that, in the case of Paul Johnson, that meals were ordered. No one said that they saw him eating anything or being given anything to eat. So it was really just, we would have done this, we did order the meals that day. And so then, at 2.11, between 7:45 a.m. and 9:15 a.m., the appellant told Inspector Lloyd that his parents had not been called, and you've got the references there, he says at EB 104, no, sir, they were not contacted. Then the further period out of the cells, from 9:15, he was removed from his cell, we say almost inevitably for further questioning, but there's no record of the interview. And obviously, if he was interviewed, he didn't have a lawyer, a parent, or an appropriate adult there. All we can say is there's a period out of his cell which could be as long as 6 hours. And during that period, we invite the board to infer that he was being questioned. He said that he was being questioned that morning and beaten up that morning. Lorenzo Johnson, who was in charge of the investigation, said he didn't know what had happened on the morning of the 29th, and that's volume 3, page 753, just didn't know, which seems a bit extraordinary from the person in charge of the inquiry. And then at 2.13, we point out that during the cross-examination of on behalf of Mr. Raming, Inspector Lloyd explained that inquiries were a line of functions, a line of investigations, a line of interviews. And whilst there's no prosecution evidence as what occurred during this period of questioning, and not a single officer admitted to being in the company of the appellant during this time, we invite the board to come to the overwhelming inference that the appellant was being questioned about the offence, as he himself said in his statement from the dock.
How many had they got in relation to this
incident in the police station that day. By then they've got 4, have they?
Yeah, I think it's
Yeah.
yes, it's 4, yes.
Sorry, for what?
Four suspects,
I see.
yes.
And how many policemen?
There were 20 policemen over the two days, yes. We can provide a list if necessary.
I mean,
Sorry.
I'm still a bit confused. On page 14, which is 9:15 on the 29th,
Yes.
the note says, McPhee upstairs, CDU to conduct inquiries.
Yes.
And you say, reasonably enough, that suggests that they were going to ask him some questions. Otherwise, what does it mean?
Yes.
What is the other side's case about what that means?
Well, the only case that they have is, well, he may have been taken up have his baggage checked, which we know happened on the 28th at 2 p.m.
They've done that, but on the 9:15 on the following morning, he says he was taken for questioning. The record says they took him to conduct inquiries. There doesn't seem to be any evidence going the other way, other than no one can remember.
No.
So it's quite a strong implication that he's...
Well, I mean, what did they say about that period?
They said they didn't know. I mean,
All the witnesses said that.
Yeah, all the police officers said, I don't know what was going on.
And the judge doesn't comment on that.
No.
Well, I don't know because somebody else was doing it, or I don't know because I don't remember, or what?
I think I don't. I certainly wasn't questioning him or beating him up during that period, is what they were really saying.
Yes, the evidence tended to focus, of course, on the rather more florid allegations that he was then relying on, rather than the case that you're now making.
Yeah, well, my lord, I do accept that.
That just happens.
Yes, it does. But of course, that's why we respectfully submit. Once the issue's raised of oppression, the burden is on the prosecution.
Yes, I understand.
But I accept that that's a complicating factor. They were saying, well, I certainly wasn't beating him up during that morning, but nobody could really explain what was going on during that period. Nobody.
One of Mr. Atwell's points at paragraph 43 of his case is that Mr. Raming was being interviewed on the morning of the Saturday, and Mr. Atwell says it would be surprising if your client, Mr. Fitzgerald, was also subject to questioning during the same period.
Well, but that presumes that there's only one officer doing any questioning, which it seems a bit strange when there are all these officers who've turned up to pursue inquiries, that there's only one person doing all the questioning, and that would be Lorenzo Johnson. Yeah.
You'd know more about this than I would, Mr. Fitzgerald, but wouldn't you expect the same officer or the same cohort of officers to be involved in interviewing all the suspects?
Maybe in taking the confession statement, but not necessarily in softening up or when I'm saying,
You just don't know, do you?
You just don't.
I mean,
Well, you
sometimes-
might have two
Exactly.
defendants being interviewed at the same time
Yeah.
by pairs, usually, and they would swap information, and they might come in and say, well, he's singing like a canary, you better do the same, that sort of thing. That's quite common, isn't it?
I'm obliged. I mean, there's absolutely no reason why, if you've got 20 officers, you don't operate in teams. I mean, you're not going to just sit around saying we'll take a blood test and check his baggage and then...
Well, we simply don't know, but you're clearly right, if I may say so. It's at least as plausible that they had different teams dealing with different defendants as that they had one. It could have been either.
Yes.
And we've no idea what else they'd got to do that day, how many of them were out, how many other crimes were being investigated, and so on.
I'm blind.
But you have got the fundamental point that it's very surprising if someone hadn't asked him something.
Yeah. Well, my lord, that's... I appreciate it's difficult that when this wasn't... Well, we just say it stands to reason, is really what we say.
Whereabouts in the police station were they when the bishop arrived?
He was in the interview room when the bishop arrives, upstairs.
The CDU upstairs?
Yes, and he's sitting at the desk, and so is DS Lorenzo Johnson when the bishop comes in, yes. So then, well, we just noted that at 2 p.m. on the 29th, this is at 2.14, Lorenzo Johnson recorded in his report that he attempted to contact the appellant's mother, Aniska McPhee. And then we have the arrival of Bishop Henfield at 3:45 p.m. For the interview he was summoned for the interview with Shavargo McPhee, and he was told that he was to come to the station to witness a statement. That's at page 174 in the cross-examination. Yes, so it's at the bottom of page 174. It looks like Mr. Ducille, the cross-examiner, has access to a statement from the bishop, because he puts at line 22, and you were told that they wanted you to witness a statement, yes. And then 25, so as you got there, you said you noticed this young man. Your words appeared to be tired. Yes, looked tired. That is the reason I asked him if he was hungry. So, that they're not phoning him saying, come along, we're going to interview this person. They're saying, come and witness a statement, i.e. this guy's going to give a confession statement. And we say that again strengthens the inference that they had got him to the point where they knew he was going to make a confession by earlier interviews. And then
So what was their evidence about where he was throughout all of this period?
There was no evidence.
I mean, beyond what we have at page 14.
No. So he was clearly out of his cells. If they're sort of no one saying, well, I was questioning him, is correct, he was just sitting around. And then then at 4 p.m, Bishop Henfield was brought into the office where the appellant was sitting down and a police officer was sitting behind the desk. And then the bishop thought the appellant looked tired. Can I just take you to the bishop's evidence at page 171? So it's page EB 171, line 8. How did he appear to you, Shavargo? A. Shavargo, when I walked into the room, appeared to me that he was tired. That is probably why the reason, as a pastor, I asked him if he eat. He looked kind of tired to me. Did he make any complaint to you? No, I did not went there for his complaint. I went to sit and listen. I remember telling him Jesus loved him. And after the officer would have spoken to him and did some writing, yes, did you sign? Give me a paper to sign. And then, I think it's probably relevant to, he's asked, has he been threatened? Was he made any promises? And he said, not in front of me. And did he, at the bottom of page 172, so this is Lorenzo Johnson, the DS in charge of inquiries, the bishop and Mr. McPhee are there. Line 21, I can't remember if he made any promises. I can't remember these things. Did he induce him to say anything? Asked him to give a statement. He gave a statement. How did he, Shavargo, appear to you at the time the statement was being taken? He appeared normal to me. He looked tired, but he appeared normal. He gave his statement. Did he complain to you about anything? No, I can't remember that Shavargo complained, no more than that he was hungry. And after the statement was taken, did you do anything? And then that's that. And I probably should just go back briefly to 169. So this is, again, dealing with when he comes into the room. So 169, line 9. Can you tell us what you did, if anything, when you went into the room? I went into the room. Shavargo was sitting down, and I remember asking Shavargo, had you eaten anything? I remember asking him that. I'm sure I did that. I remember asking him that. Question, and did he reply to you? Answer, he said no to me. Did you do anything when you heard the answer? When he replied no to me, I asked the officer why he had not eaten yet. And I said he should have eaten. I took out $20 out of my pocket and I gave it to the officer. And I said, go and buy some food for the young man to see that he eats. And then the judge, my lord, did he get a response when he asked the officer why he never eat anything? And then Mr. Colley says, do you recall whether or not the officer responded when you asked? He took the $20 from me, and apparently I believe he went and got some food for him. But I did not see Shavargo eat in front of me while I was there. I cannot remember. Court, he's asking you if the officer responded when you asked the question why the young man had not eaten. The witness, the officer did not respond to me, no. Now, the judge notably found Bishop Henfield a convincing witness, as well as Lloyd and Smith, Corporal Smith. He didn't give that accolade to either of the Johnsons. And so clearly the judge believed what Henfield was saying, Bishop Henfield was saying. The officer didn't respond to me, no. And then now, and you were in the office, Shavargo and the officer, yes. And you recall the officer asking Shavargo some questions, yes. And so he's certainly suggesting there that he asks, are you hungry? Have you been given anything to eat? He says, I haven't been given anything to eat. He confronts the officer with, has he been given anything to eat? The officer doesn't reply. And that really does substantiate the allegation borne out by the entries in the custody record too. And that's really, I think, deals with 2.16, 2.17. If I can just take you to 2.18, throughout his detention, the appellant was without the benefit of legal advice. Although it was the evidence of, it should be Sergeant Lorenzo Johnson, that the appellant had been advised of his right to a legal advisor, chosen not to request one. That's at page 213, line 2. There was no record that he was so advised prior to taking the confession, and it was the evidence of the bishop that he didn't recall the appellant being told of this right. Now, we submit that before a confession is taken, some 28 hours after he's been brought into custody, he should have been advised of his right to a lawyer by the police. And the evidence is that that did not happen. And we respectfully invite the court to look at the statement, which did, in the case of the other appellants, record a reference to being advised about a lawyer. If we look first at the question and answer, there's no page 23 and 24. There's no reference to him being advised of a right to a lawyer in the interview at pages 23 to 24. And so that, whereas there is in the case of the other, one of the other co-accused, Raming, it's actually incorporated into the questions. And then if we look at the statement, the recital at the top of page 31, wish to make a statement, I've been told I need not say anything unless I wish, and there's no reference there to him being advised of his right to a lawyer. And certainly the bishop doesn't recall him being advised of his right to a lawyer, and the judge made a finding that he may not have been advised of that right.
Mr. Fitzgerald, I'm sure it's my fault, but I haven't immediately been able to find the bit in the evidence of Detective Constable Sergeant Johnson,
yes,
that your client had chosen not to request.
Yes. Well, the reference I've got is page 213, line 2. I hope that's right.
Line which?
2.
Right at the top.
I did. Yeah. No. Yes. Did he wish to have a lawyer present? No, sir. But I did tell him.
Yeah. But, sorry. Where's the bit about that he'd chosen not to request one?
Do you have it on the record? I see. No, sir. But I did tell him that he have a right. No, I think you're right. Sorry, that's my unfortunate gloss. No, no, but so he does say I did tell him.
He does. Yeah.
Yes. He says I told him, but I failed to record it, and that he's then cross-examined about why you didn't record it. The bishop says I don't recall it, and the defendant says he wasn't told. And so we say the absence of a record is eloquent, and the fact that the bishop doesn't record him being given that advice is relevant too. So, my lord, that's the position. Then, well, the board has the confession interview, my lady. Unless it would be of assistance, I won't go through the confession interview. But we make the points at 2.19, page 1064. By that time, he'd been detained in custody for some 31 hours. The only reasonable inference, he had been questioned in the absence of a lawyer, both the previous evening and that morning. He'd been denied food and drink for some 21 hours, and the police had failed to contact his mother or otherwise notify her of his position. And we accept, of course, that the allegations he made of being physically beaten were rejected by the judge, but we say those facts alone are sufficient evidence of oppression to satisfy the test under 22A, you couldn't be sure beyond reasonable doubt that it wasn't caused by oppression that he made the statement, and also that something done or failed to be done had caused the statement to be unreliable.
Now, let's just pause there, because supposing for the sake of argument you establish that there's been at the very least a sloppy failure to record
Yes.
what's happened to him.
Yes.
He hasn't been fed, and there is no record, which there should be according to both the judge's rules and the force rules, of the fact that he's being questioned.
Yes.
And supposing one were to come to the conclusion that the inference that he's being questioned before what's on the bit of paper at 23 is frankly irresistible. Now then, where does that go? Because the inadmissibility of the confession on the grounds that it's been induced by something said or done,
Yes. Or failed to be said.
or failed to be said or done, exactly so,
Yes.
is not necessarily the same, is it?
No,
And you're entitled to say that the absence of record leaves the question wide open.
Yes. Well, my lord, I say that the things that you can find are sufficient. Can I just put it in three propositions? They're sufficient to justify a finding of oppression. On the Praga test, you look at the age, you look at the circumstances, you look at the beginning refreshment.
With a consequence that a false confession may have been made.
May have been made, yes. May have been made.
That's the bit that
Yes,
matters.
I accept it. It has to be, you can't be sure beyond reasonable doubt that the confession wasn't obtained.
Quite.
Oh, he didn't speak when otherwise he would have remained
Exactly
silent
so.
because of oppression.
Yep.
So that's the first thing. The second one, I agree, you can't be sure beyond reasonable doubt under 22B that by reason of things said or done or things not said or done, his confession was rendered unreliable, and we say that it renders it unreliable. And I accept that the board would be entitled to look at the content of the confession in reaching that conclusion on that. Thirdly, and this is the heading under which the board has normally acted, under section 178(1), it has all these failings, including the ones that my lord has identified as to the absence of any way of telling what actually did happen, justify the exclusion of the confession because of the impact of its admission on the fairness of the proceedings. And it was under section 178(1), or its equivalent, the discretion in the interest of fairness, that the board acted in the case of the juvenile in Jamaica, Ricardo Williams, yes, and also in the other case involving Bahamas, which is the board green. Well, we refer to it, but in both, there's Simmons. Is it Simmons? Simmons, yes, it's Simmons. So, I mean, in other words, I can take the board very briefly to those two cases. In both those cases, it was the impact on the fairness of the proceedings which led the board looking at all the things around to say...
What's the reference to the judges, where the judge dealt with this point, the discretion?
Yes, my lord, yes. Can I say the judge, his ruling is at page 466, my lord.
Yeah.
The judge's ruling is 466, volume 2, page 466.
Just need to keep it slight focus, don't we? You're not talking to the trial judge now. We've got to ask ourselves whether the judge's conclusions on these issues have to be set aside.
Yes, my lord, yes. And really, if I can be very brief, if we go to 466 where he makes his finding on credibility, he says he doesn't believe, he accepts at paragraph 7 without hesitation the evidence of police and civilian officers who gave evidence on behalf of the prosecution in preference to the evidence of Raming and McPhee. At 8, he says, I was particularly impressed by the evidence of the witnesses Lloyd, Smith and Bishop Henfield. He noticeably doesn't say Lorenzo Johnson or Paul Johnson. I'm satisfied the officers gave truthful evidence when they said they did not subject any of the accused men to torture as alleged. I do not accept the evidence the accused Raming and McPhee as truthful. That seems to be in relation to the allegations of torture. I am satisfied the statements were made freely and voluntarily and without any form of illicit inducement or as alleged by the accused persons. Much was made of McPhee not being told by Sergeant 772 Johnson, that's Lorenzo Johnson, that he had the right to have and consult with a lawyer. I am, however, satisfied that the absence of any notation in the record of interview to that effect was not due to any deliberate act on the part of the officer to deny the defendant his right to have and consult with a lawyer. And indeed, he may have been speaking the truth when he said it was only due to an oversight. So that means it may have been that he was not speaking the truth. It was not due to an oversight. It was due to the fact that he hadn't advised him. And it is obviously beyond reasonable doubt that the findings must be made at the voir dire. In any event, the defendant was told of his right when he was booked into the station. Well, that cannot be good enough of a juvenile to say that 30 hours ago he'd been advised of his right on admission. But the bishop, by his actions, showed that in any event, the defendant was told, yes, when he was seen by the bishop, he made no complaint, but said the bishop was hungry. The bishop, by his actions and words, showed that he cared for the welfare of the defendant, McPhee, but Mr. McPhee made no complaint to the bishop. I was especially impressed by the evidence of the bishop and feel certain that if there had been any indication the accused was suffering from the effects of trauma or torture, as he alleged, the bishop would, being a perceptive man, would have ferreted it out and taken action. Nor do I accept Mr. Dulcille's contention that the failure to give the telephone number to the defendant to call his mother was a denial of his right to communicate with his parent or guardian. It's clear on the evidence that when the police discovered the accused McPhee was a juvenile, all efforts were made by at least 2 police officers to contact the mother of the accused using the numbers he had provided as to where he could be reached. At the time, so he's finding that on the basis of the evidence of Lorenzo Johnson and Paul Johnson at the voir dire. Of course, Lorenzo Johnson corrected his evidence at the voir dire at trial. At the time, the accused lived in Nassau, where his mother also resided. None of the police officers was able to make contact with the mother. There is no suggestion on the evidence she was available, and the police misled that she could not be contacted. I'm satisfied on the evidence that she could not be contacted and made no difference who dialed the numbers provided by the accused. In any event, I'm not satisfied there was any deliberate effort to deny the defendant his Article 19.2 right. I'm satisfied that all reasonable efforts were made to contact the parent of the accused without any success. Then he refers to the abrasion on his back. I'm satisfied on the evidence that that was not caused by anything done by the police. He had no abrasions when he went in, but he had abrasions when he was checked next in in Nassau. The bishop's only comment was he looked tired and hungry prior to the interview, and he offered and paid for him to get something to eat. And had he been beaten, as he alleged, it is highly unlikely he would have only had an abrasion that was discovered on examination. Mr. Dulcille contended the police denied the defendant food for several hours, as the detention record of the accused had several gaps and omissions as to him being fed. While I accept that there may have been lengthy periods when the accused was not fed, I am not satisfied that was part of any deliberate plot to induce him to make statements which are the subject of the inquiry, which I am satisfied were given voluntarily and free of oppression. And so we say he doesn't really confront the fact that it's a very long period, not just a lengthy period, when from 7:30 really till on one day till 6:30 on the next day, when he's not been fed. And then he does deal with each of the tests. He deals with the oppression. He's not been tortured. At 16, he says no oppression, so that's addressing 22A. He says, further satisfied, no reason exists for the exclusion of the documents by reason of anything said or done, which must be the 22B test. And then section 178 of the evidence was prayed in aid. However, nothing before me would suggest in the circumstances to be unfair to admit the statements and records of interview evidence. We say we respectfully that he was wrong in paragraphs 15, 16 and 17. It may be there's more. the route the board has normally taken has been the section, the discretionary one, but to say it should have been exercised in favour of the appellant. But we say that, in fact, you couldn't be sure beyond reasonable doubt that it hadn't been obtained by oppression, and oppression can certainly include denial of food for 23 hours.
He doesn't deal with the appropriate adult point. Was that being taken at that stage? Or?
Yes, no, it was only dealt with in the context of 19.2 about the failure to communicate. No, I don't think he cited. Yes. No, there wasn't specific argument on appropriate adult. The problem is, the judge's rules simply say that it must be someone who is not a police officer and is of the same sex. However, there are Bahamian cases, including the case of Roller, which has really incorporated the appropriate adult approach. And so,
yes, but I thought one of the important things, if you can't get hold of the parent, is to make sure there's someone else.
Yes. Who's in loco parentis.
Isn't that one of the points? Of the
yes, absolutely, yes, man, yes.
And that simply wasn't done ever.
No, exactly.
That wasn't treated as part of the oppression. Then it wasn't alleged that was part of the oppression.
No, I don't. No, I think it was just you didn't phone the mother, and you didn't allow him to phone his mother.
But he didn't really focus on the sort of second line of points that you've been making, really. He focused on the key question of torture and the like, and
yes,
there's not much analysis beyond that.
My lord, that's our complaint. Yes, if
you might say there's not any analysis beyond that.
Yes,
there might not have been much to say about the identity of the appropriate adult, but there might have been something to say about the function of the bishop, assuming he was an appropriate adult.
Yes, absolutely, my lord. We say it should be someone who is known to the appellant, but in any event, as your lordship points out, there is authority that the role of the appropriate adult is to act as a protector and to at least to advise the person in private, not necessarily to stay silent, but at least to advise them in private. Clearly, in the case of a juvenile, to say you need a lawyer would be the first thing one would expect them to say, unless they got...
I mean, what seems to be missing is a point that under the standing orders, insofar as they're relevant, you set out in your case 1075, the appropriate adult comes in at the beginning. You don't wait until you've got a confession ready to go.
Yes, no, absolutely.
The whole idea is that you consult the parent or legal guardian, or failing the above, another responsible adult. And that's as soon as maybe as practical after the detention.
Yes, absolutely. Well, my lord, I respectfully agree.
I mean, there's no suggestion that whether you were attempted.
No.
There also isn't any... There's no suggestion that there was any urgency about asking questions of this suspect. I mean, why not wait for the mother till the next day?
Well, absolutely.
It would have been possible for the mother to be discovered. If you couldn't be contacted today, why not wait till tomorrow?
Well...
If you've already waited 31 hours.
Yes. Well, exactly, my lord. And indeed, she then did, when it went, or he could have been taken to Nassau, where his family were. But, my lord, given, really, I suppose it really is a question of the priorities. You know, if you regard having an appropriate adult there as an absolutely crucial safeguard, and really it ought to be the mother, then you get her there. And, I mean... Imagine if she'd been a key material witness. They would have had officers around in minutes to the address, which he shared with her, saying, we need to talk to you. I mean, Bahamas isn't a big place. It would have been very easy to locate the mother, or locate at least somebody who knew her, and identify her.
Can we just run to earth the source of the requirement for an appropriate adult in the Bahamas
Yes. Shall I take you to
as at this time? It's not just the judge's rules, is it, or is it?
Well, I'm afraid it's the judge's rules and the standing orders, and then the case.
The force orders.
So the force orders, and then the case of Roller.
Right.
Which
yes.
Which sort of, as it were.
Where's that?
So the case of Roller is.
Sorry, where is it in the standing order, in the force orders?
Oh, right. In the force orders.
This is set out in your case at page 1076.
Yes, I'm right.
Yes, it is, but...
1076 in our case sets it out. Yes. 76. So if the special provisions, if we can take it from 1075 at page 318, there are special provisions for the treatment of persons under the age of 18. The police must contact an appropriate adult. If a person in custody is under the age of 18, the station officer must, as soon as practical, inform an appropriate adult of the grounds for his detention, his whereabouts, and ask the adult to visit the police station to see the detained person. The police must inform the juvenile of his rights in the presence of the appropriate adult. Interview of persons under will only take place in the presence of an appropriate adult. And then an appropriate adult means A, his parent or legal guardian, B, a social worker, or C, failing either of the above, another responsible adult who is not a police officer employed by the police. And then it must be to question without must be authorised by an inspector, and a note of the inspector's authorisation.
There was no argument based on this before the judge?
No, I accept that. No, that's right. But the case of Roller would have been known to the parties, and Roller is at tab 29, and perhaps it gives some indication. So that's in volume 2 of the authorities.
Well, the force rules are clearly geared to anybody under 18.
Yes.
The judge's rules, as at 1964, spoke of children and young, or children as distinct from young persons.
Yes.
What did they mean in 19?
Well, I think there was a definition that a young person was somebody under 17.
I think it was.
Yes, and
I think that's right.
Child was somebody under 14.
Yeah, if child is under
Yes.
14, so,
Young persons 14 onwards. So actually the judge's rules don't help, but the force rules do.
Well, yes, and it's also the fact that they've been interpreted.
And Roller.
Yeah, Roller. Yes, Roller. If I can, Roller's quite helpful because it sets out all the relevant cases.
Did you say the parties would have had Roller in mind? So I think Roller came after the trial, didn't it, Mr. Fitzgerald?
Yes.
The judgment was the 8th of May 2012.
Yes, 8th of May. When was it? It's absolutely right. Yes, but I think some of the parties were parties to some of the other cases. But Mr. Ducil. But can I take you to 1612?
Could you just, before doing that, could you just refer to where's the reference to the age of 18 in the 4 standing orders?
Okay, it defines, yes.
Page 1229.
1229 at
20.
20, yes. He's under 18 years of age, yes.
Okay.
But it does appear that the board has taken the view that judges' rules apply to a minor in other cases, i.e. anybody under 18. Can I just take the board then to the Roller case at page 1612, paragraph 20, on the interrogation of children, the court said, this is in the Sattar Mohammed case.
So where are you?
I'm on paragraph 20 at page 1612.
1612.
Oh yes, well you have above that, there's the recitation of the judge's rules at paragraph 17. So provisions relating to statements of children from children and young persons are provided for. Paragraph 3 prescribes reasonable arrangements should be made for the comfort and refreshment. Paragraph 4, as far as practicable, children should only be interviewed in presence of a guardian or in their absence some person who is not a police officer, is of the same sex as a child. And then one has the reference to the Guyanese Court of Appeal decision at paragraph 20, then at paragraph 21 to the board's...
Hold on a minute. That's someone of 15 rising 16. It was admitted.
Yes.
What happened on appeal?
In the case of...
Held it was inadmissible.
Yes.
Yeah.
Yes. Yes, it was inadmissible, yes. Can I just show you, well, they recite PERT, the judge's rules at 21.1 are administrative directions, not rules of law, but possess considerable importance as embodying the standard of fairness which ought to be observed. Judicial power is not limited or subscribed by the judge's rules. Court may allow a prisoner's statement to be admitted notwithstanding a breach. Conversely, the court may refuse to admit it, even if the terms of the judge's rules have been followed. That may be of some importance of the rule with the force orders. If a prisoner has been charged, judge's rules require he should not be questioned in the absence of exceptional circumstances. And then at 4, the criterion for admission of statement is fairness. The voluntary nature of the statement is the major factor in determining fairness. If it is not voluntary, it will not be admitted. If it is voluntary, that constitutes a strong reason in favour of admitting it, notwithstanding a breach. But the court may rule that it would be unfair to do so, even if the statement was voluntary. Then they cite Ricardo Williams, the case of a 12-year-old in Jamaica, where the Privy Council expressed the view the presence of a justice of the peace during the interviewing, taking of a statement of a 12-year-old boy whose literacy appeared to have been in some doubt was not proper compliance with either the letter or the spirit of the administrative directions. And then they refer to the new guideline, Code C under PACE in England. Then it refers to the case of Blake involving a 16-year-old, and the defendant made it clear the person she wanted to be present at the interview was her social worker and not her father. And there was a ruling as to admissibility, an appeal by the Director of Public Prosecutions, and then in dismissing the appeal, the Court of Appeal said the justices were entitled to find the estranged parent did not come within the spirit of the Code of Practice. It's clear, and then just the last sentence, clear in such that the objective which is set out in paragraph C, to which I have referred, of the appropriate adult being of assistance and being a safeguard to the juvenile at such an interview would not necessarily be achieved. So the spirit is that the appropriate adult is of assistance and a safeguard.
Well, the point in that case was that the girl in question positively didn't want him.
Yes, yes, yes. And then at paragraph 26, they say this: we therefore urge police officers that to give effect to the spirit and intent of the judge's rules, they ought to go a step further and explain to the appropriate adult what exactly is her role in terms set out hereunder. It's important to note, under the English Code, the appropriate adult should be informed that he's not expected to act simply as an observer. The purposes of presence are first to advise the person being questioned, to observe whether or not the interview is being conducted properly and fairly, and secondly, to facilitate communication with the person being interviewed. And then it deals with the question of whether the brother, who was 23, was an appropriate adult, and concludes he wasn't. And then, but perhaps that is important because it's the Bahamian Court of Appeal saying that you've got to give effect to the spirit and intent of the judge's rules, which goes beyond mere have you complied with the letter of the judge's rules and is informed by the English law approach to an appropriate adult. And really, that is justified in our respect for submission by the fact that in the end, the question, the discretionary question is, will the admission of it have an impact on fairness? And in looking at what is fair, you can look at standards elsewhere. You can look at the spirit and intent of the judge's rules, and certainly given that these principles are prescribed in the force.
Your best point, though, in relation to the materials which were available, which in this case, of course, wasn't available because it hadn't yet happened, is really paragraph 20 of the force rules, isn't it, which says if the person in custody is under 18 years of age, the station officer must, as soon as practicable, inform an appropriate adult of the grounds of his detention.
My Lord,
an absolutely clear obligation, which was your difficulty was that it wasn't relied upon before the judge. Perhaps,
no, my Lord. The only additional point I'd make is that there is authority that you can look at. what is regarded in another jurisdiction as appropriate or what is regarded as later as appropriate in determining what is fairness when you're a reviewing court. And that's, it's cited in Ricardo Williams, the case where Lord Bingham looks at the change in the rules and says that can inform our sense of what fairness requires, even though it's a subsequent development. Where's Ricardo Williams? Ricardo Williams is at, tab 31, and that's the exclusion of the confession of a 12-year-old. But could I just draw attention to the fact that there's a reference there to the judge's rules, and they... Yes, if one really looks at the final ratio, paragraph 28, most important, the judge should have given consideration, so that's page 1645 of the manual. Judge should have given consideration to the sovereign requirements of fairness, so the sovereign requirements of fairness in deciding whether to admit the statement. Both the trial judge and the Court of Appeal appear to have taken the view that voluntariness was the sole criterion of admissibility, but for the reasons given in that view cannot be sustained in an unqualified form. Their lordships must therefore give consideration to the issue of fairness. And then they look at the literacy, no parent was asked to come, and a number of factors. And then at paragraph 28, their lordships will assume for the purpose of consideration of fairness, admitting the statement, the judge was entitled to hold that no beating or other maltreatment occurred. Nevertheless, even if this is accepted, the circumstances of the appellant's detention and of the taking of a statement as such as to create a significant amount of unfairness, their lordships cannot conclude that in all the circumstances of the case was fair to admit the statement. And so we do submit that that is relevant. And there is, I'm so sorry, I'm trying to track it down, but it's quoted in one of the authorities, a statement by Lord Bingham, where they're looking at a case 12 years, where they've extended time by 12 years, and saying you can look even at the new code under pace in a case where it didn't apply at the time, because it informed one's sense of what is fair and whether the conviction is altered by fairness. It's a case which is usually cited because of the generous extension of the time. It's Ashley King, yes, it's at tab 20. And Lord Bingham, so it's tab 20. And there. Yes, I think it may be page 1522 at 402 at the top. Yes, at page 1522b, in looking at the safety of the conviction, it is relevant to consider whether and to what extent a suspect may have been denied rights which he should have enjoyed under the rules in force at the time, so that's the force rules, and whether and to what extent he may have lacked protections which it was later thought right that he should enjoy. So both what was in force at the time and what has later become acknowledged as necessary to achieve fairness are relevant. And then he says, so it's really that dual test. What were the safeguards at the time and what has now been recognised to be necessary in order to achieve fairness are both relevant to the determination at the appellate level. So we would say that that's why Roller becomes significant. That's really those are really the points that I think I've summarised the judge's findings. If I can then very briefly summarise, at part 3 we've dealt with the constitutional rights point, and the board has our submission that the right should have, it's at 1068, the constitutional submission is probably best picked up at page 1078 at part 4, where we say essentially that you don't afford, if you don't afford him an opportunity personally to phone his parents, you don't afford him a reasonable opportunity of communication. And that's so if he is not personally afforded an opportunity to phone, the right is being denied. We have summarised that at 4.4, page 1079. The trial judge failed to appreciate it was the appellant's right to communicate, not the police officer. So the appellant should have been permitted to attempt to contact his mother himself. And we know that he did get through to her when he got to Nassau and was allowed to call. And secondly, such a finding that all efforts were made was an unreasonable conclusion. It was insufficient to make those phone calls. It underestimates the imperatives of the constitutional requirement. And they should have gone round and found the mother. And we put that at 4.6 at page 1080. And obviously, if there has been a breach of the constitutional right, then we'd say that is a very significant factor and that weight has to be given to that in determining both the issue of unfairness under 178 subsection 1 and the issue of admissibility and oppression under the Evidence Act, section 22A and B. Then we've set out our submissions at page 1085 on section 22A, and really, I think I've summarised them, my lady. Yeah. We say he's been detained for 31 hours before he confessed, without access to a parent and without legal counsel. And despite the fact the trial judge found that he'd not been provided with any refreshment for lengthy periods. That, we say, is enough. Moreover, we say there's an overwhelming likelihood that he was questioned in undocumented and unrecorded interviews for lengthy periods, at least on the afternoon and evening of the Friday and on the morning of the Saturday before he confessed. And then 22B is dealt with at page 1086.
An important point you make is that the judge sort of focused on whether it was a deliberate plot, rather than the objective question of whether one can be sure that it was safe.
Absolutely. We say,
yes, I mean, that's right. But though when it comes to exercising what is in the Bahamas section 178 discretion, relevant factors would include, would they not, the gravity of any breach and also whether they were deliberate or not.
I entirely accept that one. Yeah. It's a relevant factor whether there's bad faith, but it's not determined. It's not necessary or sufficient.
That's under section 178. You're dealing here with section 22A.
Yes.
Which is a slightly different text.
Yes, and yes, if there's
22A is quite strong on your side because you simply have to make the representation, raise the issue, and then it's up to the other side to prove beyond reasonable doubt that it was a safe confession.
Yes, and the test of oppression under 22A is the wide one in Praga. You look at everything. You look at the age. You look at whether they've been fed. You look at all the rights. I again accept that in relation to the question of oppression, whether there's deliberate bad faith or maltreatment would be a relevant factor. But again, you can have oppression without bad faith. You can just oppress someone. It does seem unlikely. I mean, the silence of the officer when the bishop says, has he been given anything to eat, is perhaps an indication that they weren't being that careful of his rights or treatment. And that, Sergeant, that's something that's in the evidence which the judge found compelling.
Thank you.
And then 22B is again, have they proved beyond reasonable doubt it's not rendered unreliable by those things done or not done? And we would submit that they haven't discharged that burden beyond reasonable doubt. And again, in looking at that, all those factors about the special nature of the safeguards that are appropriate with juveniles, which we've summarised in the passage about the law, would be relevant. I'm not going to, unless my lady, you wish me to go through the law, I'm not going to do so. But
well, I think you've set it out very
yeah,
fully and clearly in your printed case.
Yes, I mean, perhaps the only thing that is the international element, which is perhaps not so familiar, that these are the rules for treatment of juveniles are underpinned by the Inter-American Convention, the UN Convention on the Rights of the Child. So perhaps that's of some relevance.
Well, you mentioned that when we were talking about the Constitution.
Yes, my lady. We have set out what the Inter-American Commission said, and there's a case involving Argentina, which is cited in. It's a decision of the Inter-American Court, emphasising the importance of the point, really, that my Lord Cardinal put to me about the parents should be there from the start, as it were. And so those are all those points. And then you have our submissions on unfairness. We rely on the case of Ricardo Williams, Volume 2, Tab 31, which I've taken you to, with the case of Simmons and Green, which is at Volume 2, Tab 30, where the Bahamian Court of Appeal itself emphasised the importance of ensuring fairness. Can I just give you the references there? It's in Simmons and Green, is at tab 30 in volume 2, and that's at paragraphs 24 and 25 are the key ones. So tab 30 is Simmons and Green is, yes, just before the Ricardo Williams, page 1621 onwards. But can I just... Yes, perhaps at 1631, whilst acknowledging, as the board already has, the judge's entitlement to find that police here did not deliberately frustrate constitutional rights, their lordships nevertheless conclude that on the fact of this case, so this is the board, the only proper decision open to the judge was to exclude the statement. And there was an element of frustrating the access to the lawyer there, so there was a deliberate element. I accept, but they referred to the importance of vindicating the rights, and the importance of the constitutional right to see a lawyer is emphasised at paragraph 26. So if there was a failure to advise him of his right to see a lawyer, he being a juvenile, at the beginning of the confession interview, then we say that's a highly significant factor on the authority of Simmons and Green, which is the board dealing with an appeal from Bahamas. I think those are the only authorities, my lady, that I need to just emphasise. And so we have set out the breaches of the rules and the standing orders at 6.3 on page 1090. And we certainly interviewed in contravention of Appendix B4 at 6.3 Roman 1, because the questioning wasn't recorded. And then at page 1090 at Roman 2, the appellant was not treating compliance with police best practice as set out in the 4 standing orders. Police almost certainly interviewed the appellant in the absence of an appropriate adult, almost certainly conducted interviews that were not recorded, made no attempt to contact social services before approaching the bishop, and failed to provide the appellant with any refreshment for some 21 hours. And we say that the judge failed really to deal with that issue of fairness, the sovereign requirement of fairness referred to by Lord Carswell in the Ricardo Williams case. Then we've set out in more detail the breach of the judge's rules and standing orders at part 7. I don't think I need to take you through those. And at part 8, we've dealt with the trial judge's failure to direct the jury. This is the Mushtaq.
This is the Mushtaq point,
yes,
isn't it? Yes.
And really what we say is the trial judge should have directed the jury to consider whether the circumstances surrounding the taking of the confession evidence might have rendered the appellant's confession unreliable or caused by oppression. We've set out what the judge did say at 8.2 on page 1098. And what he says is about 2/3 of the way down that quotation: if you are satisfied beyond reasonable doubt that the confession was not obtained in this case. I think it must mean in this way. Yeah.
Yes.
Is what he said.
Yes.
And that it is true, you may take it into account. And basically, he seems to be saying that if they believe the appellant's account of maltreatment and other oppressive circumstances, or found his account might be true, then they were to disregard his confession. But we respectfully submit this direction failed to inform the jury what they should do if they were to find only some of the appellant's account may have been true, especially given that there were events, in particular the denial of access, the food points and all those other points, which were objective facts.
That, of course, hadn't been part of the case, had it?
Well, certainly Mr. Ducille, before the jury at trial, did make great play of the food point.
Of the food point?
Yes, and also of the lawyer point. He cross-examined at some length about why didn't you record it at the trial. So the lack of lawyer. It's true that he didn't, before the jury, take the lack of appropriate adult, but he did take the point about you should have told him about the lawyer. He did take a point about the lack of food, and he was saying to the officers, "Come on, you were questioning him."
Yes.
So there were those points. So we say that it didn't comply with the Mushtaq and test, and we've really set it out at 8.4 at page 1099. He should have them to direct them to consider, regardless of whether there's any oppression, or whether the police had deliberately frustrated the appellant's constitutional rights, it was rendered unreliable by those facts. Now that concludes everything except for the miscarriage of justice. I would respectfully submit that the significance, if the board were of the view that either under the discretionary power or under the statutory power, this should have been excluded, then the confession was a very substantial part of the case against him and the conviction cannot stand. And that really is the point. On the appeal against sentence, my learned friend takes
That's conceded. Yes.
That's conceded, so I don't need to address that.
Yeah.
But how does it take 5 years before it's realised that the sentence is entirely unlawful?
Well, actually, to be fair, Chief Justice of Appeal Conte, who had been the Chief Justice in Belize, says, I've got my doubts about this. But you mean, why didn't they do something?
Yes.
Yes. Well, my lord, I'm afraid there are bad delays in the. My learned friend Miss Morley may be able to assist us on that, but I think that he's effectively saying, I don't think you've got jurisdiction to make a life sentence, and the other judges, of course, not doing anything. He was the Chief Justice of Belize, and very distinguished.
Yes, we have encountered his remarkable decisions, notable decisions.
Yes.
In that capacity. Yes.
Many important decisions on the death penalty too, so he, as it were, raises the red flag, but nothing happens.
At any rate, now it's common ground.
Yes, that's right. So he did that. No, then the only other point is the further point, and
Your manslaughter point.
my manslaughter point, and obviously it is an alternative. Because were we right about the admissibility of the confession, that would be our respectful submission that would render the conviction unsafe of itself. But we do respectfully, and I do apologise for the fact that we didn't spot it before. I think I can only say I was on the other ball, but it may be that this is a point that is of some importance. That really, if I can take you to the confession statement itself, we say that raises the issue of lack of intent. And in Bahamas, the intention that's required is an intent to kill under the statute. It actually expressly says that it must be an intention to kill. But then there's this strange extended definition of what intention can be, but it must be an intent to kill. So if I can take the board to his statement, he says at page 32, about half the way down, then I point the gun at him and tell him not to move, and I went up close to him, and me and him started to hassle. He was trying to hold my right hand with the gun in it, so I start to squeeze the trigger, and some shots gone off. I call for Vardo to come, and he come in the back, and I walk out after the guy let me. So it's, he starts to squeeze the trigger after the other person is holding his hand, the gun in it, and he says some shots gone off. Now, we say that is at least open to the interpretation that it was not an intentional killing, that during the course of a fight, he was caused to squeeze the trigger, or did squeeze the trigger, but without the intention of killing. And we know that then the injuries were one to the abdomen and one graze across the chest. So the graze across the chest is certainly consistent with, as it were, a random shot going off in the course of struggle.
Is it an automatic pistol, or what kind of pistol is it?
They do describe it.
I mean, what I mean, in effect, is do you have to pull the trigger twice?
I see. My lord, I'm really sorry. I didn't actually think that one. But I will try and get the answer to that. Yes, I see. Well, it may be important. Yes. But there is a story, and the injury seems to have gone up through the abdomen, the fatal one. It's not an immediately obvious place if you're just shooting the person to kill him rather than in a struggle, and it's certainly consistent with a shooting in the course of a struggle. At any rate, we do submit, and this is Roman 1 on page 2 of our supplementary case number 2, that gave rise to an issue of manslaughter, and significantly at volume 3, page 817 to 818, the co-defendant's counsel, not his own counsel, Mr. Sherland.
Sorry, what page is that?
Page 817. And I think he's really complaining about the unfairness that the principal may be guilty of manslaughter, but the secondary party would be guilty of murder on the direct. That seems to be. He says, Mr. based on the prosecution's rely on that becomes a relationship that is totally unique with one individual, either McPhee or Raming. This is at line 12. It's that part when they talk about the hassling for the weapon, and at the stage you have to put an alternative with respect to an accident because it takes away the intention. So the judge says, so you think accident is something that should be included, even if you take it at its highest, it would still be an unlawful harm. Well, that's the judge clearly talking about manslaughter. And if that happens, that direction perhaps would be weak. I'm saying that direction would only be unique to Mr. McPhee. I'm just looking at it worst case scenario. And if the jury was to come up with worst case scenario manslaughter, then that would be a substantive charge of murder being open to Mr. Raming. I think that's on the basis that if he's foreseeing some level of harm, that he could be convicted of murder, although the principal's guilty of manslaughter. That obviously is a point that's been made often. That is one concern that I have, my lord. The judge says, it seems to me, even if you are asking any harm cause, would be the question whether it was intention. Defence is that he was not there. So to leave accident means you have to put him on the scene. And that's the Coutts error. Well, your defence isn't. Your defence is not, it was manslaughter. Your defence is, it was nothing. Therefore, I'm not going to put the alternative. And that's what Coutts says you shouldn't do. You should say whatever on the evidence is supported. And Mr. Sherman, well, the court has to put whatever defence is available. And whether it was put by the defence or not, the court has to put it there. So he's completely right there, Mr. Sherman. Is that accident? I'm just looking at the word in literal in the case of armed robbery. Takes away the mens rea of murder. It's no longer there. I think my biggest concern is, and let's say in the evidence the court sees a self-defence, has to give that option to the jury. That's what the authority speaks to. So we really sort of say, as it were, amen to everything Mr. Sherland says, But we don't really know what then happened, because Mr. Colley at page 821 for the Crown says, Mr. Colley, my lord, in relation to what Mr. McPhee said, the caution said about Hasley, and he said Mr. Strachan was trying to hold his hand, his right hand, the hand the gun was, and I fired off some. The issue is, my lord, whether or not that activity brings into focus lack of intent. And if it is lack of intent on his part, lack of intent to do what? To kill. That it means the issue of manslaughter. In the case of Alexander Stark, I think the Privy Council matter out of Jamaica. So that's, the Stark is cited in Coots. It's the case where they say you must leave anything that's available on the evidence, whether it's the defence case or not. And he goes on, this is the prosecutor, it's my lord, be lack of intent upon, Cease was trying to hold my hand and I pulled the trigger. But is that self-defence? No, but it is an answer. And Mr. Colley, this is a tough one. I can't see intent in that, perhaps, if he had it. So he's raised, those issues are being raised. Well, then when we get to the summing up, the judge says, I'm going to ponder that. There doesn't seem to be any kind of comeback. I've thought about it and I'm going to decide. But then we get his summing up. And at page 832, the judge says, at line 26, prosecution, can I take it from 23? The prosecution case is that whoever fired the fatal shot must have intended to kill him. Given that we cannot tell that it is in a person's mind at the time he does that, you may ask, how does the prosecution prove the person who fired the fatal shot intended to kill him? They rely on a rule of law contained in section 12(3) of the Penal Code, and that provides as follows. If a person does an act of such a kind or in such a manner as that, if he used reasonable caution in observation, it would appear to him that the act would probably cause or contribute to cause an event, or that there would be a great risk of the act causing or contributing to cause an event. He shall be presumed to have intended to cause that event until it is shown that he believed that the act would probably not cause or contribute to cause the event. Now, the board has interpreted that as an evidential, putting an evidential burden only on the defendant, although it seems to have its origin in the old law in Smith. But in any event, this board has interpreted that as just putting an evidential burden to raise a belief. And we would say that the statement, partly exculpatory, raises that belief, or at least raises the question of whether he had that belief.
Belief? Sorry, what belief?
Well,
it's a question of intent, isn't it?
Well, he says it. Yes, but yes. He get the fact when he says it, the gun went off, and in the course of the struggle, that raises, in our respectful submission, an inference that I didn't intend to kill him.
I've got that.
Yes, sorry.
But I'm sorry, I'm not quite understanding where belief comes in. That's all. Perhaps I misunderstood. Don't worry.
Well, my lord, I have to say I have some difficulty with 12(3),
yes.
But it's been interpreted by this board, by Lord Hobhouse in this board, as simply putting an evidential burden on the defence to raise an issue of lack of intent, really.
But you say, where do you say they did raise a burden? Because I mean, he says he starts to squeeze this trigger with this chap standing in front of him.
Well,
if you do that, there's surely a risk that someone may get hurt or indeed killed.
Yes, but he was trying to hold my right hand with the gun in it. Well, there is express authority that says recklessness is not enough, even under 12(3), although one would think that 12(3). Right. I mean, I better show you your lordships that.
But the thing says, I mean, there he is squeezing the trigger.
Well,
and he doesn't say I wasn't intending to squeeze the trigger.
Well, except that does he squeeze the trigger because he's being pushed, or because he's being hassled? I mean,
well, you'd have it.
You mean it sounds volitional? I start to.
Can that happen, Mr. Fitzgerald? I suppose it.
Well, if you're holding the gun and the person is fighting with you, I would say you could start.
Well, I suppose if he holds the trigger finger, as it were.
Yes.
Mm.
Well, All I can say is it certainly appeared that way.
You're saying the
to both
judge would have interpreted that as raising the issue of whether...
The prosecutor thought it gave rise to it. So did co-defending counsel.
Yeah.
The judge didn't say, don't be so silly if you squeeze. And then the judge says, well, it's clearly murder. He doesn't even leave the issue.
Yes, I mean, he carries on and says there's no basis for self-defence or partial excuse in this
Yes.
matter.
Yes.
And
And
says
then,
that on 834.
Yes. And then over the page, at page 835, you may, at line 22, which is pretty surprising given what's just been said by the prosecutor and the defence, you may think, members of the jury, that having regard to the directions of law, the evidence that there is no question the murder occurred. In other words, it's a murder. There's no question of lack of intent. There's no question of a possibility of manslaughter. You've just got to decide who did it or whether they did it. And we would say the issue was all right. Can I just then, my lady, take the board very shortly, because so we say you've got to leave manslaughter if it arises on the facts that there may have been a lack of intent. That's the case of Coots, which could I just invite hand up both Coots and Rahming, and perhaps Mario Pinto. Coots, Rahming, they should be on the right hand side. Coots, Rahming, and Mario Pinto.
Do we have Lord Hobhouse's?
Yes, we do. Yes, that's Rahming. Yes. Yes. Okay. Fine. Yes. Rahming is Lord Hobhouse, and it's dealing with section 12 was then 11.3. So, well, can I then take the Coots establishes the principle you've got to leave anything, even if the defence don't want you to, and even if it's not their case, and it's
certainly if it's not their case.
Yeah. Yes. And then it quotes.
Not quite the same as if they don't want you to.
Yes. Yes. And Coots cites the case of von Stark.
Yeah.
At paragraph 14, I think it is, where this board says, it's page 2161F, 2161F of Coots. There's a long citation from von Stark, and
there's been quite a lot of law on Coots, hasn't there?
Yes.
Subsequently.
Yes, but I don't. Well, it hasn't been reversed. I know. It's caused problems, but if I can put it moderately. 2161F, but if there is evidence on which a jury could reasonably come to a particular conclusion, then there can be few circumstances, if any, in which the judge has no duty to put the possibility before the jury. For tactical reasons, counsel may not wish to enlarge upon or even to mention a possible conclusion, etc. But if there is evidence to support such a compromise verdict, it is the duty of the judge to explain it to the jury and to leave the choice to them. In Xavier and the State, the defence at trial was one of alibi, but it was observed by Lord Lloyd. If accident was open to on the evidence, then the judge ought to have left with the alternative of manslaughter. In the present case, the earlier statement, together with their qualification, amply justified a conclusion of manslaughter, and that alternative should have been left to the jury. So if it's a reasonable possibility that the jury would find manslaughter, then it should be left, is your Lordship's board and my lady's board decision in von Stark, and also paragraphs 23 to 26 of Lord Bingham saying you must leave lesser verdicts where they're raised on the evidence. And that's paragraph 24.
So in a sentence, what had Mr. Edgecombe's evidence been referable to intent?
Nothing. I mean, he just...
None.
Just intend to rob that.
He intended to rob, yeah. He says, I took them there, they wanted to rob. I picked them up after it happened.
He wasn't in the shop at all.
No, he wasn't in the shop.
I see.
So he can't throw any light on that. Then basically, can I just show you Rahming, where Lord Hobhouse is interpreting 11.3, which was the predecessor of 12.3, and he cites it. So it's at page 364G. So it's in identical terms. And he says at H, section 11.3 is an evidential provision. It does not mean that it suffices for the commission of the crime of murder the defendant was reckless, i.e. that he recklessly discharged it. Intentionally causing the death of another is an essential ingredient of murder, although in discharging this burden of proof, the prosecution can rely upon a rebuttable presumption of fact under 11.3 in the same manner as the proof of primary facts may lead to the inference of a further fact. Yeah. That is, after all, the normal way in which intent is proved. And he cited the fact that there has to be, there must be an intention above that at page 300, at F, at Code Provision, section 3111, whoever intentionally causes the death of another is guilty of murder. So it's got to be an intentional causing of death. It doesn't allow for malice aforethought. And then at 366, at paragraph 17, so 366E, in their lordship's opinion, these directions on the crime of murder risk the confusion in the minds of the jury between the ingredients of the crime of murder and that of manslaughter, and risk the jury returning a verdict of guilty of murder when they were only satisfied that killing must have been reckless and ought to have returned a verdict of guilty of manslaughter. The trial judge considered upon the evidence he ought to leave for the jury the alternative verdict of a guilty of manslaughter. Their lordships can understand why he should have taken this course. The confession evidence, which was an essential part of the prosecution case, spoke of there having been a fight which led to the death of Teresa. The autopsy evidence was that she had suffered a very severe fracture of the skull, which was the cause of her death, and would require a very severe blow. There clearly was evidence upon which the jury could properly have found the killing was murder, not manslaughter, but it cannot be said that the conclusion was the only one open to the jury. It was not a case like Dean, where the victim had in the course of robbery been shot twice in the chest at a range of only 6 inches, or Mohammed, where the victim's throat and neck had been severed back to the level of the cervical vertebrae. So we would say that likewise a shooting in the course of a struggle, or as a result of a struggle, where one of the injuries is a grazing to the chest and the other is an upwards trajectory from the abdomen, you can't say from that it could only be with intent to kill. And so we do respectfully submit that despite the wording of 12.3, it's been interpreted to require still a subjective appreciation of the probability or great risk of death. And that issue was open. And we submit that at Romans 6, that the judge going so far as to direct the jury that there was only an issue of, it could only be murder and armed robbery, and the only question was who, was misdirecting the jury. And at Romans 7, at page 3 of our note, we say that the trial judge should have left any alternative offence which there was evidence to support. And one, that included the potential defence or potential conviction of manslaughter. There is a more recent case called Pinto, which I should just very briefly show the board. Can we have Pinto? Which I think was coming to the board on a prosecution appeal, but sadly the prisoner died. But that contains that's the Bahamas Court of Appeal looking at this whole point. Yes. And this is about whether there should be about a no-case submission. Can I not go through all the details of the case, but just take to the key passages in the judgment of the Honourable Mr. Justice Newman, who will of course be familiar to the board, who was sitting in the Court of Appeal. There, it's at page 17. He says, at paragraph 54, as to what the judge had to have in mind in considering the no-case submission under these subsections, was what degree of probability was there that death would ensure...
I'm sorry, where are you?
Page 17, paragraph 54, under the heading 12, section 12.2 and 12.3 test, my lady.
Thank you.
So at paragraph 54, as to what the judge had to have in mind in considering the no-case submission under these subsections was what degree of probability was that the death would ensue from a single hit with a hand, then to consider whether it would have appeared to the defendant to be a risk, and next whether there was evidence to show he did not believe it to be a risk. There may be cases where the degree of probability of death ensuing from an act will be so high that a jury will be able to be sure the accused believed in the probability of death ensuing. This was not such a case. Nevertheless, the jury would have had to consider all the relevant evidence to the issue as to what belief the accused in fact held. So the issue in the end is what belief does the accused in fact hold. In cases where the prosecution rely upon the presumption to give rise to primary facts of the existence of a risk assessed objectively, there has to be evidence upon which a jury can be sure the accused used reasonable caution and observation. That had the accused used reasonable caution and observation, the risk would have appeared to him.
Well, now that's the
Yes.
relevant bit, isn't it?
Yes, yes. Well, they've got to be sure. And we say, and it's got to be the great risk. And then at paragraph 56, the difficulty with the first part, the reference to a reasonable man, is the judge directs the jury that such a person would have appreciated is equated to the notion of the defendant. You are entitled to presume that he intended the death of that man. The he must be a reference to the accused. There was no direction to the jury that they had to consider what would have appeared to the defendant. And of course, one has to take the defendant as he is, a 17-year-old involved in a struggle at the time, whether it would have appeared to him that there was a great risk of death. Is at least something that we say should have been left to the jury. And then, if it's not that, then we say it should have been left to the jury the question of manslaughter. And I know that it's strictly speaking impermissible, but the House of Lords in Coots recognised that a jury faced with the alternative of murder or nothing may think we're not going to let this person get away with it. Yeah. Whereas if they're given the alternative of murder or manslaughter, they may find that that's the more appropriate verdict that fits the facts of the case. And therefore the removal of that intermediate option in our respectful submission does work in justice in a case such as this, where there's at least some room for confusion as to what he did subjectively appreciate in terms of the great risk of death in that split second where the 17-year-old is confronted with a struggle. I don't know whether
It works both ways, doesn't it? The jury dynamics can work either way.
Yes.
You can have exactly the problem you've just identified, or you can have the case where the assessment of those defending the defendant is that the jury may not wish to go so far as murder.
Yes.
They might well go so far as manslaughter. I mean, the dynamics are not the test.
No, I appreciate it. I accept that that's not the test, but it was one of the underlying points made. I think the way they put it was, in reaching any decision in life, we're influenced by the range of options that are presented to us. Yeah. And that's just a factor of psychology. And therefore, it underlines the need to leave manslaughter if it's reasonably open on the facts, which is I accept that is the test, and that's why we would say that it was reasonably open on the facts, and that after all, both the prosecutor and the co-defendants counsel seem to have acknowledged that it arose on the facts. And we don't know why the judge then went so far as to say it's clear there's murder here. So that is our alternative submission, with apologies to the board for having not identified it sooner. And
Well, it's not so much the board that you should apologise to, but your opponent.
Well, I have grovelled in
And
my...
I'm sure you've done that already.
And he very kindly indicated that he thought it was my duty to raise it if you know, it arose. But I do apologise to him for the late identification of the issue.
Mr. Fitzgerald, may I just ask two things, purely for information? The first is, have we got the evidence of the ballistics chap in this case somewhere? There was a match made between the casings in the
No.
thing. No, I'm sorry, I may be wrong about that.
No, there was a match.
Okay. Well, we will. Yes, there's the post-mortem, isn't
That won't help.
But
It's the examination. If there was an examination of the guns, all right. Thank you. If we haven't got it, we haven't got it. And the other thing I want to ask, please, with some delicacy and obliquely, could you turn up page 17?
yes.
The last two entries on page 17 and the penultimate entry on page 19 prompt me simply to ask this question: was there any evidence at all either at the voir dire or the trial about whether any questioning of the defendant was directed to any other possible inquiry? I don't want to ask more than that.
No. 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 I think the answer is no.
Right. Thank you.
We'll double check, but I think
That was my impression, but I haven't read everything. That's the point.
Yes, I think there may have been further questions asked when he went to.
That's always possible.
Yes.
But in any event, it may not much affect your fundamental proposition, which is that there must have been some questions about this.
Yes. My lord. My lady, unless I can assist the board on any other matters, those.
I think not. Thank you very much, Mr. Fitzgerald. Thank you. Ms. Cliff-Matthews, do you follow?
No, thank you, my lady.
Mr. Atwell.
Ladies and Lords, subject to the board's approval, that I propose to deal with the issues is in the following way. First, I'll deal with the Article 19 breach of constitution point, and that's the point regarding communication with the appellant's mother. Secondly, I'll deal with the exclusion of the confession evidence under the provisions of the Evidence Act, and in particular, I'll deal with the fundamental points that are made by my learned friend, namely, one, prolonged period of interrogation over the 28th and 29th, 2, the allegation that the appellant wasn't fed, 3, that he was not informed of his right to a lawyer, and then I'll move on to deal with the pastor's role as an appropriate adult and the alleged breaches of the false standing orders and judges' rules. Lords, I'll deal with the Mushtaq point. I can deal with that relatively briefly. And in the time that I've had available to peruse the authorities, I'll attempt to assist as much as I can with regards to the new point that's raised by my learned friend, the manslaughter point, and whether that should have been left to the jury as an alternative verdict. So I'll leave that till last, my lords. So far as sentence is concerned, that's accepted. I don't propose to add anything further, save for what's already set out in the party's case, the appellant's case and the respondent's case, which are effectively agreed. And with that in mind, my lords, I'll start to deal with Article 19.2 of the Constitution in the time that I have available before lunch. The starting point is the detention record itself. I'll just ask your lordships to turn that up. It's in Electronic Bundle 1, page 10. Now, my lords, my learned friend took you to this page at the outset of his submissions, and the short point is this. At the time of his arrest, the appellant was informed at that time that he was to be afforded, or he had a right to be afforded a reasonable opportunity to communicate with his parent or guardian. This is on the left-hand side of that page, page 10, and you'll see that he was signed. That part of the record was signed by the appellant himself. Now, in that respect, the evidence, so far as that's concerned, is set out in Sergeant Johnson's evidence. If you go in the same bundle to page 286 over to 287, and just ask your lordships to have a look at Sergeant Johnson's evidence as to what it was that he informed the appellant of. This is line 27. He's asked the question, what, if anything, or any dealings did you have with Mr. McPhee on his arrival at the station? He says, well, my dealings with him was to make sure that the detention record was properly explained to him, which indicates his rights under the Constitution 1902, which he had a right to get a lawyer and have a counsel with him. I also made efforts to contact his parents, let them know that he was in custody due to that he was a minor. And then the relevant point here is I tried over and over all day, even to the next day, and I didn't get no contact. So you did make efforts to contact his parents, yes, ma'am. You have a bit more detail in Valentino Smith's evidence, and that's again in the same bundle at 178. Just invite your lordships to have a look at that. This is page 178, line 27. Just prior to line 27, he notes that Sergeant Johnson prepared the detention records for the persons that were detained. He explained the detention record, informed them again of their reason for being in police custody, also informed them that they had the right to seek counsel, consult with counsel without delay if they wished. On realising that Mr. McPhee was a juvenile at the time, Sergeant Johnson asked him if he had any relatives or guardian in the Aberco district for him to contact them so that they could be informed that he was in police custody. Mr. McPhee informed that his family lived in Nassau. Sergeant Johnson requested a telephone contact for his guardian, which he provided Sergeant Johnson. As a result, Sergeant Johnson handed the telephone contact over to Inspector Partier to have the guardian of Mr. McPhee informed. And what's said in the appellant's case is, well, that's somewhat inconsistent with what then follows with DS Johnson's evidence. It's said that the transfer of the telephone contact to Inspector Partier was not accounted for in the evidence, and that's right. Inspector Poitier didn't give evidence during the voir dire or the remainder of the trial, but what's the relevant point is this, that in re-examination, and this is at page 185 and through to 186, this is lines 30 to 2 on 186, he confirms that effectively that was the end of his involvement, Valentino Smith. So he wasn't able to say what happened after that initial arrest and initial encounter with Sergeant Johnson at the police station. So we say that isn't a relevant matter that arises so far as attempts by the police are concerned as to attempts made to contact the appellant's mother. Well, you then go to DS Johnson's evidence at the voir dire, and you get that at page 203. And this is at line 18 through to 31. Just before line 18, he's asked the question, based on his age, can you tell the court what you did, if anything? Well, before, as a matter of fact, from the 28th, I'd asked him where his mother was, and he told me she was in Nassau, just pausing there. No indication that an address was given at the time. And he gave me her name, no indication again that she lived at the same address as the appellant, Aniska McPhee, and I asked him for her phone numbers, because I wanted to call her to tell her he was in custody and he needed an attorney and all of that. And he gave me two numbers. He gave me a cell and a phone number from the 28th. Did you make attempts to reach her? Yes. Tell us about that. I made several attempts on the 28th and also on the 29th to call her. I dialed the numbers and I did not get any answers from either of the two numbers. Now,
Mr. Atwell, you say no evidence about address being given. Of course, there is an address on the initial detention record.
Yes, and that's the appellant's address, but there's nothing on the detention record which suggests that his relative, his mother, resided at the same address. And there's no positive evidence that he indicated to the police that that was the case. I'll just come on to deal with one further aspect of D.S. Johnson's evidence, because he then, at trial, altered his evidence somewhat. He said that he didn't actually make the phone call on the 28th, that it was the other Sergeant Johnson that made the phone calls. And I'll just show you that, my lords. That is at 673, and that's volume 3. It's line 5 of volume 3, page 673. D.S. Johnson, I asked him her name. He said her name was Anishka McPhee. I asked him if she knew where he was. He said he didn't know. I asked him for her phone number, which she gave me a cell phone and a home number. Then asked Ramin where he got his money from. And he said he worked for that. And then a bit further down at line 17, Miss Anishka McPhee, I gave him the 2 numbers. I asked him to contact her to inform her that her son was in police custody for questioning reference to, and that's Sergeant Johnson. You get that from earlier on, a bit higher up at the page at lines 13 through to 15. And then again at the bottom of this page at line 32, he says, I asked Sergeant Johnson to contact Miss McPhee or attempt to contact Miss McPhee throughout the day to let her know that her son was in custody for questioning, reference to armed robbery and murder. And that's on the 28th. Now, he was pushed on this in cross-examination, and at 732, line 24, he was asked, sir, do you have it in your report, sir, that you tried contacting his mother on the 28th? Yes, and on the 29th on both days. You asked me if I have it in your report that I tried to call his mother on the 28th and 29th on the 29th. Did you contact his mother on the 28th? I informed the sergeant who is in charge of the shift. I asked you a simple question, you know. I would like to answer your question. You don't have to go through all of that. You wouldn't allow me to answer your question, sir. Did you try to contact his mother on the 28th? No, sir. So what you have, and what I accept, is an inconsistency in D.S. Johnson's evidence from his evidence at voir dire and to the evidence at trial in respect of his attempts to contact the mother on the 28th. But what you also have is the evidence of Sergeant Johnson that he made repeated attempts to contact her on the 28th and 29th. You also have the evidence of D.S. Johnson in any event, which is that he attempted to contact her on the 29th. So the sum total of it is there is evidence, and there was evidence before the judge, that attempts were made to contact the appellant's mother throughout the period of his detention, from his initial detention on the 28th through to the 29th, up to the point of his confession.
I mean, we're dealing with a constitutional right at the moment. Are you saying it's enough under the Constitution that you've made attempts to contact the parent, and
Yes.
then and if you can't get her, then that's the end of it, is it?
Well, yes, the point about Article 19.2 is it's not an absolute right. Article 19.2 is confined to simply affording a
I
detained
understand,
person.
but it does seem rather odd that if you can't get hold of her, then you don't have to do anything else. But under these standing orders, if you can't get hold of the parent, then you have to find an appropriate adult.
Well, there's nothing in the judge's rules or in the full standing orders which prescribe what it is that the police actually are required to do so far as communication with the parent or guardian is concerned. What the full standing orders do is simply repeat Article 19.2 in terms. They don't go further and say, well, actually, if you can't contact her by phone, then you've got to go out and find her. They don't go as far as that. And there's nothing in the judge's rules to that effect either.
I thought they did.
My Lord, no. So far as the full standing orders is concerned, they're in Authorities Bundle 1, Tab 5. And what you have with regards to communication with a parent, at electronic bundle page 1224, you have Article 19.2 recited in terms and then at page 1228, paragraph 17, in accordance with Article 19 of the Constitution, a person who is arrested or detained has the following fundamental rights, and all officers will ensure that such persons are given an opportunity to exercise those rights. Namely, and then you have bullet points 1 and 2, and then 3, in the case of a person under the age of 18, to be afforded a reasonable opportunity for communication. Now, what it doesn't go on to say is, well, how one goes about how one goes about complying with that constitutional right.
How about paragraph 20?
Yes. Well, the obligation is as soon as practicable, and that's in respect to an appropriate adult.
Right. So that in relation to an appropriate adult, as soon as practicable, somebody has to be found.
Yes.
And the inference is you shouldn't be carrying out, save in extremis, no doubt, any investigation or at any rate interrogation until that's been done.
Well, my
here, no such thing was done. Now, I take the point that the point was actually taken at the trial, but
yes.
There we have it.
Well, my submission is that there's an obligation under 19.2 to ensure that the parent, or at least a reasonable opportunity is afforded to communicate with the parent. There's no absolute obligation that the parent has to arrive under either the judge's rules or the full standard.
I have your parent point. I'm talking about the provision about...
20 and 22. I mean, 22 says appropriate adult means either the parent or guardian, or failing the above, another responsible adult who's not a police officer. And presumably the whole point of that is to make sure that someone who's a juvenile has someone independent to talk to at a very early stage.
Oh, so I accept that.
And you accept that in this case no one seems to have given any attention to that at all.
Well,
to be fair to you, you are currently dealing with the constitutional right.
Indeed.
And you're going to come on to deal with
and
the
I will
other
come on to deal with the appropriate adult.
I don't mind to deal with it, as long as we deal with it sometimes. But it does seem to me that looking at the Constitution, it clearly, there's a question my lady asked earlier, what's it for? Is it simply about making sure that the parent knows about it, which is obviously very important, but is it also to ensure that the detained person has someone who can provide some assistance?
Yes. Well, the reason in my submission for Article 19.2 is simply it can work both ways. One, it's in favour of the individual that's detained, to ensure that the parent is put on notice, his or her parent is put on notice, and the other way is, as I think Lady Hale pointed out, that actually it can work in favour of the parent as well, so that the parent's put on notice that their child has been detained. My submission is this, that so far as 19.2 is concerned, it's right that the police had an opportunity or made attempts to telephone and contact the appellant's mother from the point of his original detention through the 28th and on to the 29th, because if your lordships are with me with regards to the timeline, the first interview of any relevance is the interview at 4 p.m. on the 29th, which is the confession interview. And prior to that...
Well, we don't know that, do we?
Well, I'm going to come on and deal with...
no interviewing in the meantime.
I'm going to come on and deal with the relevant timeline in due course, because I don't accept that on the 28th there was an interview of any relevance, and the prosecution didn't seek to run an interview of any relevance at trial on the 28th. And in terms of the 29th, the complaint was that on the morning of the 29th, the appellant was detained, beaten by the police, and the police called evidence in response to that. And the judge in those circumstances was entitled to, I say, prefer the evidence of the police over that of the appellant. Now, it might be, and it is the case that, and we've accepted this in the case, that the detention record doesn't provide a full and complete or accurate account as to the chronology of his movements in and out of his cell over that period of the 28th and 29th. But so far as the constitutional point is concerned, I say, well, it doesn't arise here because you do have evidence, and the judge did have evidence, that attempts have been made. His treatment of that is set out in his ruling in the voir dire it's useful to have a look at that. It's in volume 2, page 467. And it's paragraphs 11 and 12. Paragraph 11, certainly in my version, is badly photocopied.
So is mine.
Yes.
I mean, as Mr. Fitzgerald was reading, I was filling in
Indeed.
blanks. It's not entirely satisfactory.
No.
I wondered whether to mention it before. I didn't. But actually, since you have, it would be better for us to have proper copies of this.
Well, if we can obtain them, we will provide them. My best guess as to the missing blanks is this, that paragraph 11, nor do I accept Mr. D. Seale's contention that the failure to give the telephone to the possibly defendant to call his mother was a denial of his right to possibly communicate with his parent or guardian. It's clear on the evidence that when the police discovered that the accused McPhee was a juvenile, all efforts were made by at least 2 police officers to contact the mother of the accused. The numbers he'd provided as to where she could be reached. And at the time, the accused lived in Nassau, where his mother also resided. No suggestion, again, certainly so far as the evidence before the judge was concerned, that accused and mother lived in the same building. None of the police officers was able to make contact with the mother, and there's no suggestion on the evidence that she was available. And the police misled him that she could not be contacted. So 2 specific factual findings reached by the judge. One, no deliberate frustration of the appellant's rights in terms of contacting the mother, but also 2, that she simply wasn't available. I'm satisfied on the evidence she could not be contacted, and it made no difference who dialed the numbers provided by the accused. In any event, I'm satisfied there's no deliberate effort to deny the rights under 19.2. Well, what I say very briefly is this, that was the correct approach based on the evidence that was before the judge at the time. He was entitled to make those specific factual findings that the mother could not be contacted, and also that there wasn't a deliberate attempt to frustrate the appellant's rights. And what my learned friend says, and I'll just deal with this first point very briefly, is that, well, actually the appellant ought to have been permitted to make the phone call himself. Short point is this, Article 19.2 doesn't go that far. It's not, same point again, it's not prescriptive about the manner in which the phone call is made. There's nothing that bars the police from making the phone call by proxy on behalf of the appellant. And in those circumstances, there's nothing to suggest either in those instruments or in the full standing rules or the judge's rules that the appellant was required in order for his constitutional right to be vindicated.
Was there evidence that he was told at the station that the attempts to contact his mother had failed?
No.
I mean, if you're told, well, we've tried these numbers and we can't contact your mother.
Indeed.
He might have said, well, try this 3rd number.
Indeed. Well, the point is there was no evidence either way. So, similarly, there was no evidence that the appellant said, well, how are we doing with attempts to contact my mother, and no inquiry in that respect either. There just simply isn't any evidence either way on that point. Well, the second
That seems to be an appropriate moment at which to adjourn, and we'll look forward to hearing from you further at 2 o'clock.